Today, NBC News reports that special counsel Jack Smith is in court trying to force former Vice President Mike Pence to testify in response to a subpoena as part of the DOJ's sprawling January 6th investigation. NBC News' Ali Vitale sat down with the former vice president earlier this evening and got his reaction to that news.
The idea of subpoenaing a former vice president to testify in court against the president with whom they served, I believe is unprecedented in American history. But as I said last week, I believe it's also unconstitutional.
Of course, the former vice president has had no problem discussing his interactions with Trump on January 6th as part of a nationwide media tour to promote his new book. And now Pence's refusal is drawing criticism from a towering conservative figure whose advice Pence previously sought. Former federal judge Michael Luttig, whose counsel Pence desperately sought during Trump's pressure campaign in the days before January 6th, Luttig argues today in the New York Times that not only is Pence's position just flat out wrong, but that Pence's criticism of the subpoena as a political maneuver could not be further from the truth. Luttig writes, quote, "The only question now is not whether Pence will have to testify before the grand jury, but how soon." Jack Smith's subpoena was neither politically motivated nor designed to strengthen President Biden's political hand in 2024. Thus, the jarring dissonance between the subpoena and Mr. Pence's characterization of it. It is Mr. Pence who has chosen to politicize the subpoena and not the DOJ. The legal titan who advised Vice President Pence in the most perilous moment of his career is now publicly questioning Pence's legal strategy, which is probably as good a sign as any that his legal argument is maybe, perhaps, moot. Joining us now to figure all that out is Barbara McQuade, former U.S. Attorney for the Eastern District of Michigan and professor at the University of Michigan School of Law. Barb, thank you, as always, for being here tonight. My first question is, Michael Luttig, who was an important advisor to Mike Pence, is just tearing apart his legal argument for not complying with the subpoena. First and foremost, he says it's not a question of if, but when, and the courts will decide on this soon. Do you agree with that, that if this is a delay tactic, it's not going to work in Mike Pence's favor?
Yeah, I think that's right, Alex. I mean, Judge Luttig is a lion in the conservative legal community. It's really fascinating for him to take such a public stand on this issue, especially, as you said, he was the one who was advising Mike Pence back on January 6th, and now to make this bold statement. But I think it's right. I mean, Mike Pence is being very aggressive here in trying to hide behind a shield that's intended for legislators to protect them from harassment by the executive branch. It's quite a stretch for him to claim that. But even if it does offer any protection whatsoever, it is not a complete shield from even appearing before the grand jury. He would have to assert it on a question-by-question basis, even if there are some things pertaining to his activity on January 6th while he is acting as president of the Senate and certifying the vote. It certainly doesn't apply to everything within his knowledge about the events of January 6th. So I think Jack Smith will prevail here, and I think it will result in some delay. But, the courts seem to be moving rapidly on some of these privilege claims. And so one hopes that they can get Mike Pence before the grand jury in short order.
Yeah, he suggests, and I'll read a little bit of the Luttig op-ed. The courts quickly disposed of Senator Lindsey Graham's speech or debate clause claim, requiring Graham to testify before the grand jury impaneled in Fulton County, Georgia. And his claim, that's Lindsey Graham's claim, was far stronger than Mike Pence's. It is in the unlikely event that Mr. Pence's claim were to make it to the Supreme Court, it too could be expected to take swift action. He sounds like it's not even a question that the Supreme Court would rule in Jack Smith's favor. Do you agree with that?
Yeah, I think that's right. It seems like such a stretch. Mike Pence says this is unprecedented. No vice president has ever been subpoenaed to testify against the president he served with. Well, that's because this situation has never occurred in the history of the United States. So, of course, it's unprecedented. But there is really no reason to think that Mike Pence does not have an obligation, like everyone else, to appear before a grand jury. There's an old adage that says a grand jury is entitled to every man's evidence, every person's evidence, and you can't use privileges designed to protect one branch of government as a shield to protect yourself. He has asserted executive privilege, and now when it suits him, and now asserting the speech or debate clause, which is a legislative privilege when it suits him. I think that even if these privileges safeguard some aspect of his communications, it's not going to safeguard all of it. He's going to need to show up.
Yeah, you're talking about the speech and debate clause, which technically would protect some of the experiences and commentary and conversations while he was president of the Senate that day. But Luttig goes on to make the point that, you know, Mr. Smith, Jack Smith, the special counsel, wants to know about Pence's communications and interactions with the president, Trump, before and perhaps during the vote count, which are entirely fair game for a grand jury investigating possible crimes against the United States. There's plenty that happened outside of his role as president of the Senate that the special counsel will be interested in, if not more interested in. And so you agree with Luttig here that Pence, if he wants to invoke the speech and debate clause, is going to have to do that question by question. It can't act as a blanket to prevent him from testifying.
Yes, that's right. And I think there may even be a waiver here. For one, he's talking with a member of the executive branch. So if he wants protection as a legislator, he seems to have waived it by talking to Donald Trump, who is a member of the executive branch. He also may have waived it by writing all about it in his book. And so anything he wrote in the book, I think, would be fair game. And then also, Alex, there is an exception when there is a conversation about future activity to advance a crime. And that's how prosecutors investigate bribery cases. If a member of Congress could always say, well, you can't ask me anything about my vote because I'm protected by the speech or debate clause, you would never be able to prosecute a member of Congress for accepting bribes. And that's done all the time. So I think there are a number of ways for Jack Smith to get around this. It seems that he's being appropriately aggressive in asking the court to rule in his favor and command Mike Pence to appear before that grand jury.
Yeah, you know you're in trouble when your former lawyer is basically saying Jack Smith has the upper hand here and your argument is flat out wrong. Barb McQuade, thank you for your time tonight. Always good to see you.
Thank you, Alex.